I'm ready.
That's because you are an amazing young lady and you're
Oh,
all
thank you.
ready.
So are you.
Yay. So now I'm going to go and set it up on my Facebook and we're going to go live. I'm going to start that. And we're just going to have us a good time. That's all
How
we're
come
going
I
to
can't
do.
hear you though?
You can't hear me? Let me turn my mic up.
No, not very loud, and mine are at 100%.
There, let me turn it up and see if that's
Okay.
better. Hold on. There we go. All right, so here, let me go live here. And let me add a title.
You know I love you, Teresa.
I love you too, darling.
And I don't even know you that well, but I love you anyway.
You are amazing. All right, so we got this, and now I just need my go live button and we'll be good to go.
Okay.
Let's see here. It's setting it up. And this is going to be awesome.
Do this.
We're going to have fun. And that is going on. It should be going on right there. So now let me go to my page and let's see, is it happening? Cool. So I'm just going to put that aside. I don't want to look at the Facebook page.
Okay.
Because it just confuses me.
Okay. Whatever.
I don't like to be confused, girl. So what I want to talk to you about, I really want to understand, I want to understand probate. I want to understand a will. I want to understand a trust. And I know that you're the person that can help me understand because you are phenomenal. So what I want to start with, just tell me about yourself, how you started and how we ended up here.
Okay, well, I am the managing partner of Bailey and Romero. I've been in the law profession for 33 years, wanted to be a lawyer since age 11, and in fact called to be a lawyer. So here I am 33 years later in the law profession.
How did you know that was your calling?
Planted deep in my soul, and then through speech and debate, starting in 7th grade and 8th grade, and then all through high school, I just said, if arguing is this, I am in.
Oh man, what was your first case?
Oh my gosh, I can't remember my first case because when I was hired as the first Latina at the county counsel's office, out of 160 attorneys, I was given 8,500 cases to conclusion or judgment. And so 8,500. So I can't tell you my first case, but what I did is I put them in alphabetical order. Somebody said, well, what if the statute of limitations blows in the Z and you're A? And I said, these 8,500 cases have been neglected for 5 years. So if it blows in the Z until I get to the Z, it's not my problem. I have to start at the A's.
Right. That makes sense. That makes sense. Oh my God, for 5 years. And were you able to get through all 8,500?
Well, in 6 months, I got them down to about 2,000. And another 6 months, I probably got them down to 200 because I went to court every day.
Oh my God. Now, is that typical that you're in court every day? Is that unusual?
Only when you're a litigator. So a litigator means you're going to try to get a judgment, and that can either be by going to trial or by agreeing with the parties that they're going to be on a payment plan. These were all collection cases for either personal property taxes, welfare fraud, or restitution, or medical lien, some kind of money that was owed to the county of Los Angeles.
Wow, that's a lot. That's a lot. That's a lot of work. I bet you would go home just exhausted.
Well, I was pretty young then, so.
That's awesome. So when you left that position, where did you go next?
Well, after 8 years, I didn't really see someone like me being ambitious and wanting to learn new things. I didn't really see anywhere to go up because the county counsel's office at the time when I started had no women in management, no women roles. I was the only Latina. There was 1 Asian, 2 Blacks, and 2 Latino men, but that was the extent of the minorities. And so when you face a ceiling above you of Caucasian men of about 155, and they've been there for years, there's really no place to go. So I left and I went to Alvarez, Glassman and Colvin, which is a small firm. And I'd never been in a law firm before because I was working for the government. And they were a small firm that represented cities, redevelopment agencies, districts, school districts, water districts. They were all municipal law again. And they told me because I had been an attorney for 8 years that I could pick and choose what I wanted to do.
Wow. Oh my goodness. That is so exciting. So what did you pick and what did you do?
Well, when I was at the county, I learned how to represent the county as a creditor in bankruptcy, because when I was a 3rd-year lawyer, Marina Del Rey went bankrupt. And it was 2 partners. And so there was competing plans on how to reorganize the marina. But the county of Los Angeles built the marina. So all the land leases on all the hotels and all the houses and everything. They had the dock slips. They had everything. They were owed billions of dollars. And that was my first case as a 3rd-year lawyer, Chapter 11, in front of Judge Calvin Ashland, who was then, well, I don't know if he was then, but later he was the presiding bankruptcy judge. And that case lasted for about 3.5 years. And I learned how to do Chapter 11. So when I went to Alvarez, Glassman and Colvin, they asked me if I had any specialties or if I could get clients. I said, I kind of do. And I said, if you will pay for me to go to conferences, I have this specialty, and that is how to represent a municipality in bankruptcy as a creditor. And if you send me, perhaps I could get clients.
Outstanding.
So they did. And that began the beginning of obtaining clients.
Outstanding. So you have a long history of experience. What led you to the probate trust side? How did you get there?
Well, after obtaining a numerous amount of county clients, I looked around, and I was the only woman at the firm, by the way, another only first. And because I was the past president of the Mexican American Bar Association, I had some leadership qualities because I got elected. And I just decided that after I had been there for a couple of years that I would start my own firm, because it was always a dream for me to start my own firm. Nice. So I did. In 1998, I opened the Romero law firm. And at that time, I brought all of my county clients. I was then the general counsel for the Channel Islands Municipal Water District. And so I brought all of that as my base. And then I wanted to represent people, because representing governments is one thing, and I love it, but I also wanted to represent real people. So in 2005, I added to my practice Probates, Wills, and Trusts, because really I had represented the treasurer tax collector at the county and the assessor. I knew a lot about real property. I knew a lot about valuation. I knew a lot about title issues. I also represented the register recorder. So all with those 3 departments.
Yes.
That was setting me up to, wanting to do real property issues. And probate is just clearing title in another forum.
Mm-hmm. So let's talk about the difference between a will, probate, a trust, a living trust, a revocable trust. Why are they good? Why are they not good? What do you recommend? You can start where you want to.
No problem. So a will is a legal document that you draw up in order to distribute your assets after death. And so is a trust. But here's the big difference. We do not recommend at Bailey and Romero that anyone does a will if they own real property. And this is why. If you have a will or you don't have a will, you're going to go to probate court. You're going to pay filing fees, appraiser fees, other kinds of court fees, as well as 4% of the value of the property of the first 100,000, 3% of the next 100,000, and 2% of every other 100,000 after that. So the heirs are going to pay a lot of money just to inherit the property. It's also a very, very long process. So it could be very expensive and it could be very long. And plus, the process is public. So anybody could be sitting in the courtroom and listening to how you're distributing all the assets. But a trust, a living trust, is what we recommend at Bailey and Romero if you own real property, because a trust is also, like I said, a legal document that is intent to transfer your assets after death. But first of all, it's private because an attorney drafts it. It doesn't get it recorded, even though many people think it does get recorded. It does not get recorded. And you can set forth everything that you want in the trust, even if you want to disinherit one of your children because they were, you know, they were on drugs, or they did this, or they did that, or whatever. You can also leave it to organizations, nonprofit, your church. I mean, anybody that you want to leave it to. And it's all private. You're not broadcasting it in a courtroom and saying, I'm going to leave it to this, this, and this, and this, which is very important to people, that their distribution of assets be private. The only thing that gets recorded in a living trust is the deed. So at Bailey and Romero, we prepare the living trust, the pour-over will, the financial power of attorney, the medical power of attorney, the HIPAA, which is how your heirs or whoever you name can get medical information, because you're an adult and they're not going to give it to those adults unless you do a HIPAA release. And then the living will, which also says that you really, if you desire, that you don't want to be on a ventilator for forever, because you know that you're not ever going to recover. And we prepare also the paperwork, the legal paperwork, to transfer the family home or whatever other real estate you have. It could be apartments, it could be, you know, other real estate, it could be land, it could be anything, into the trust. If you don't do that, which I caution people, because many trust mills who don't have attorneys, they never do the deed. And so if you never do the deed, the trust is not funded and the trust is void.
That's right. Oh my God. You know, you hit a key point. I never thought about the public when you're doing the probate and you have to go before the court. And I remember I got a traffic ticket once and I had to go to court, and I'm sitting in there, and you're right. There are hundreds of people at least sitting in there hearing your information. Most of the time you don't know anybody, but just in case, you might have a friend of a friend. Oh man, Teresa was in there and she's cutting her daughters out. She's not giving them anything. That is so important.
Or even someone you might not know, say, hey friend, I heard this really, really, really hot story about Teresa. She's doing blah, blah, blah. And then she blasts it on Facebook, and you're just like, hey, why is my estate being blasted on Facebook?
Exactly. Even for the children, you know, I have this $10 million estate. I'm leaving it to my kids. Well, now they're going to bump me off and go find the kids and bump them off to get the money. So that, oh my God, I never thought of that.
The other thing is, there are times, and I've done many estates where they do want to disinherit the child, because either the child walked out the door at 18 and said, you know, something like, I'm never going to see you again. And then they have no idea where they are for years and years and years and years. They never come around. Or maybe they're into, you know, other things like drugs and alcohol, or they're living on the streets or whatever. So they know if they leave them any kind of money, they'll just go through it. So I've had to deal with many estates that have that component where the trustor wants to disinherit somebody. And then I have people that don't even have natural children, and then they leave it to organizations. And you know, it's really fun to call up a church and say, guess what? So-and-so just left you $1 million. And they're like, what?
Oh my goodness, that's true, because there are some people who are single and they don't have anybody, or everyone has gone before them and they're the last person. So when they have the living trust, and now it's time for the family to sell, usually that's a smooth process. Those are the type of deals that I have done where they do have the living trust and it's been a smooth process. What about the ones when they do have to go through probate and the family aren't getting along? How do you handle that situation?
Families often don't get along, as we know. We know at the Thanksgiving table, people may not get along and people may not talk to each other, brothers and sisters not talking to each other for years. So how we handle it is myself and my probate paralegal, we call a family meeting. And what we know is what we know, and that's human nature. And even the kids that aren't talking to the other kids, or the sister isn't talking to the brother, they're curious because we call a meeting and say we want to talk about the family estate. Of course, they want to go and find out what is going on, even if they're not talking. Now, sometimes I've had cases where the kids start yelling at each other and we say that is not appropriate. We will end the meeting and we will have another one and you can calm down. Some people have walked out. Some people, their emotions get to them, which is kind of sad because we should try to control our emotions. And even if you don't want to talk to your brother or sister, you could just take notes and then, you can hold your anger in. But sometimes it's too much for people and sometimes they do spew the anger. But we are there to control it. And, we may ask that person to leave, or like I said, we might just have another one. It just depends. If it gets really, really bad and people are really not getting along, we'll suggest to hire a professional mediator.
Ah, that's good.
And we often will ask the court, let's say they're opposed to that too, we will then often make a motion before the court or just a request before the court that they order us to mediation. Because if the kids don't go to mediation, then they're going to be fighting in court, spending all the mom and dad's money on attorney's fees. And really, is that what mom and dad wanted? No, mom and dad probably just wanted you to get along and like zip up your lip.
Exactly. That's good. So you're awesome. You have thought of a lot of everything and you're handling the business. Now, let's talk about the family that has a reverse mortgage. The reverse mortgage is involved. The family members did not know that the owner did a reverse mortgage and they didn't have a will. They had nothing. What's the first step they need to do there?
They had nothing? Okay.
They had nothing, no will, nothing.
First of all, let's say they had a will or a trust. Let's just say, and then I'll go answer your question. I never recommend that the mother and father or whoever my clients are share copies of that with their children because this is what's happened and it's happened several of my cases. The kids will use undue influence and alter those documents when mom and dad are maybe a little sick or they're in the hospital or they broke a hip or maybe they have bronchitis. Mom and dad, the daughter or the son or whoever will use a little undue influence and go, hey, you said blah, 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 but I don't really like blah, 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 and I'm your favorite daughter or I'm your favorite son. And so could we just kind of X that out and you could kind of write this in? I've also had several kids, not that, the normal person would do this, but they have forged deeds and recorded them. They've gotten mortgages after they forged the deed. There's a lot of crazy stuff that goes on. And of course, we don't recommend that parents share their trust documents. Even though they may say, oh, my daughter or son will never do that. Many parents have said that, and many sons and daughters have done that. So we all know that when money is at an issue, it's just like J.R. Ewing and his brother in Dallas.
Yes.
Now let's say they don't have anything. They don't have a will, they don't have a trust, parent dies, then they're the heir or they have other siblings, then they have to go to probate, unfortunately. And then they have to before they can sell, they have to be issued letters. Now people often ask me, how is it that some courts require court approval and some don't?
Yes.
Well, it matters on what authority you get in the letters. There's either full authority or limited authority. And so that's the difference. Sometimes when you're asking for full authority, if in fact there is no will or trust, and the house is valued, let's say, at a higher amount, then the court may require a bond, and some people can't qualify for that bond. So they don't ask for full authority. They have to ask for limited authority because they just don't have the money to put up that for that bond.
That makes
The
perfect.
court doesn't want anyone selling property and then taking that money and going off to Mexico for a vacation.
Exactly. That makes perfectly good sense. That makes sense, because that was always my question. Why would we have court confirmation versus non-court confirmation? And it depends on the authority the person has to sell the home. So if
And then oftentimes what happened is the home doesn't sell, let's just say, because whatever. It's a fixer-upper, they don't want to put money in it, whatever reason. Then sometimes they'll do an auction in the courtroom, and then those are really fun to watch because people will show up and they'll bid this. It's like just like a regular auction on the court steps. So on a foreclosure, they'll offer this and they'll offer that, and then they'll offer this, and the court's sitting there going, okay, you raise your hand. And I mean, it's just like an
wow. Did not know that. And so this would happen, like you said, if the house doesn't sell, or if the family members can't come to some sort of agreement as to who's going to be given the authority. And then time runs out.
Well, the family members don't really decide who's given the authority. They usually discuss like who would be the person nominated as the executor. And the issue is this. So let's say, Teresa, they say you're going to be the executor, but let's say you have siblings, and let's say you have one that doesn't like you. So you can file an opposition to your being appointed executor. And let's say that, or let's first say they just show up at court and they do a verbal. I don't want Teresa to be the executor. So then the court will then set another date for a hearing and give them time to file a written objection, because you can't just say, I don't want Teresa. You have to have reasons, like really good reasons. They can't just say, I don't like Teresa, so I don't want her to be the executor. They have to have really solid reasons. And then mostly like, you've done something illegal or you've been arrested. Well, even if you've been arrested, it depends for what. But in other words, they don't think that your moral character, with a bunch of reasons.
Got it.
That the reason. And then the judge decides, not the siblings, the judge decides whether or not. Now, if you only have one objection, and let's say you have 5 siblings, the judge is going to still appoint you because he doesn't have enough. But let's say you had 4 objections against you, then that's like the majority. And if they were all had good reasons, then you would not be appointed the executor likely. The judge would say, oh, okay, there's these problems and 4 of the siblings are saying this.
Got it. Oh my God, this is such valuable information. It's a lot of things, because families, or some families, they don't talk about this. So they don't know what's going on, what's behind the scenes, until they're in it. You mentioned.
And the other thing is, siblings often don't know what the motives are behind other siblings.
Right. That's true. You mentioned a lot of important documents inside of the living trust. You mentioned one about being able to handle the finances, being able to handle their health care, being able to put the property in the trust. That's extremely important. I have a trust, and exactly every single thing that you said, it happened exactly like you said it. They gave me a pack of paper. They gave me a big giant notebook with a packet of papers. Okay, you take this to the bank. You take this to your retirement place. This is your deed. It's going to be mailed. It's going to come back like this. And if anything changed, you come back and you see us, and we review it every 3 years. So that is so important to be able to do those things. You are phenomenal.
Especially if children die. So I had a client where they had 3 children die, and she's still, the parents are still alive, but she had 3 children die of cancer. So you have to then readjust the who you're going to leave the assets to. And that, it's a pretty easy thing. You just do what's called an amendment.
Okay.
Do a first amendment, a second amendment, a third amendment. I mean, unless you're going to change major things in the trust, you just do amendments, because that's inexpensive, and you don't want to redo the whole trust again for, $2,000, $3,000, $1,500, whatever they're quoting you. I mean, then you keep paying it every time you want to change a little thing.
Exactly.
And some firms will charge you just a flat rate, and they'll include any change, like any changes from here on till the end, until you die. And so, but it's a little higher because you may want to change it, and especially if you live for a really long time and you have the trust done when you're relatively young, you may have numerous changes as you go on, especially young families. If they do a trust and then they have kids, then they're going to want to include those children in the trust. Or another thing that they may want to include is any adopted children, because when you adopt, you have to declare before the court under oath that you agree to treat them as an heir of the estate.
Okay, that's good. So, and again, if they're adding children, the grandchildren, they got married and divorced, whoever they're adding, very simple, they can do an amendment.
Yes, and many people, I've had very few clients that add the grandchildren because
interesting.
They just leave it to the children and then
let the children decide. Ah.
Especially if the grandchildren are wayward too.
That makes sense. That makes sense. Oh my goodness.
Often people will say, like, say you're an heir.
Mm-hmm.
Say, so if Teresa dies, and let's say Teresa, you have 4 children, then they will distribute your share equally to the 4 children. So maybe you only have a 5th or a 4th or a 3rd, depending on how many siblings are. But many of them don't. They really don't want to keep dealing with, like, okay, and then if those grandchildren aren't alive, you know, so they just basically deal with the children. And then the children, of course, if they're going to get an inheritance or part of the property or personal property, whatever, then they can give it to their children. And they, you know, they just, I don't have many clients that really include the grandchildren.
Okay. Okay. Well, that makes
sense. Or one more thing. You can just give like a specific amount. Like you could say, like I did have a client that said, I'll give, you know, $500 to Sally, and I'll give $500 to Jimmy, and I'll give, you know, but it's not like a whole lot of money. You know, it's just like maybe they're young students, or maybe they're in high school, or, you know, you don't know. And then so they just give them like a simple amount, like a small amount of money, or it could be 1,000, I mean, whatever, but it's not like it's 5,000 or 10,000 or 50,000.
Okay. Oh, this is excellent. 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 So now let's go back to the probate. We found the person who was named the executor for probate, and they want to fix up this property to sell it. Do they have to spend their own money first and get paid back out of the estate, or can they go into the money that may be in the estate to pay for those things? How does that work?
Well, we suggest, well, it depends how much how much money is in the estate. Because remember, first of all, it's going to take, well, this is pre-COVID, so I don't know what it is post-COVID, but pre-COVID, you know, would take 60 to 90 days to get the letters. So now I'm not sure. But anyway, forget that it's even COVID right now. It's still going to take 60 to 90 days. Okay. And you have what's called probate attorneys that are on staff at the Superior Court that will tell you everything that's wrong with your petition for executor. Like, let's say maybe you proofed the whole petition, but you forgot to X some box. Mm-hmm. Just say, like, really no fault of your own. You just missed it. You're a good attorney, but you didn't X some box. Mm-hmm. So many days prior to the hearing, the probate attorney puts out what's called probate notes. And then they will tell you, oh, you failed to mark box whatever. And then all of a sudden the attorney goes, oh my gosh, like, how did that happen? Did my secretary just forget and I marked it or whatever? So you can always, right prior to the hearing, file what's called a supplement. So you can file an amended petition even up to the day before the hearing and say, we fixed that, Your Honor. We marked box whatever. And here you could often bring a copy, because if it's a day before, they're likely not to have a copy. And the judge usually says it's okay. You know, if they're really busy though, they might say it's not okay, just because they're really busy and they have so many cases on the docket and they haven't really had a chance to look at it. Now they have to just look at it right then and there, you know, so it depends. But most judges are experienced probate judges, and they will say it's okay, especially if it's like a minor thing. If it's a minor thing, but if it's a major thing, no, they're going to continue it and make you even maybe not even do a supplement, do it all over again, you know, and then file it, because it just depends if it's a major or a minor. And it also depends on the probate attorney. Sometimes the probate attorneys are fine, and the probate attorneys have the right to recommend. So they could just say, oh, Miss Romero forgot to mark box whatever, but it was only the date, or it was only, you know, or it was only whatever, you know, whatever it is. And then we recommend that if a supplement is filed, it would be approved.
Excellent.
And they would put that in the notes, but you can log on to the notes. Some of them put them in as many as 3 days before, some a little longer, some just right before the hearing. So technically you might not see them if you're like busy all that day before, but hopefully you have somebody checking the probate notes for you, like your assistant, so that they could tell you that, oh, this has happened, or it's all perfect, or they could post it's all perfect and they recommend approval.
Okay.
They can also recommend approval without going to the hearing. So it's called, there's a technical term for it, which I don't remember right now, but they can say approve, and then they can say, you know, no hearing. And then you don't have to show up. Client doesn't have to show up, and that's good.
Outstanding. So this is good. This is good. So while they're waiting that 90 days, is it okay for them to start doing some work on the house or whatever it is they need to do, or they need to
Nope.
choose?
No, because they don't have authority.
Mm-hmm.
Go back and answer the real question. So usually we recommend they get a loan, because remember, they're not going to be able to touch the bank accounts, because the standard day to get a death certificate, I mean, you can get it earlier, but what they allot is 45 days. So if you don't have the death certificate, you can't go to the bank and fill out the necessary paperwork to get the bank account. And then different banks require different paperwork. So I wish it was all standard, but it's not. I mean, I wish they would do, every bank would just say, okay, you only have to fill out, you know, 10 pages or 5 pages or whatever. And it's all the same. You could download it, blah, 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 because then you can have it ready. But all the banks have different things, and you don't really need to have the bank account in the trust. So if your bank account doesn't say, you know, the Romero family trust or the Miller family trust, you're not dead in the water. But every bank requires something different for you to get the bank account. So you're waiting 45 days to get the death certificate, okay? So it's kind of like almost the same getting the letters and getting the authority to get a bank account. So, or longer for the authority, because it's now taking 60 days. I mean, you could get it shorter, but we just tell people it could take 60 to 90 days, just to like, so they don't think it's going to be in 2 days. Because what people don't understand is probate is a process, which means that it could last a year or 2 years. It just depends how complicated the distribution of the assets is. And it also depends on, and people don't understand this, is how backlogged the court is. Your case goes in a pile. Let's say there's 800 cases above you. Then they try to tell you, well, hurry it up. Well, once we send it to the court, there's nothing we can do. We can't call the judge up and say, could you move us to the top of the stack, please? Because we know there's 800 cases, but we need to be at the top. Yeah. No, we can't do that. So a lot of people do not understand that it's a process. Of course, we try to get the probate done in a year, but if there's a delay in the court, or we can't get hearings, or there's fighting, or whatever, it's going to take much longer. And some probates last for years and years and years and years and years, because there's a lot of assets, there's a lot of, you know, complications.
Wow. So in the meantime,
that they get a loan. Okay. We recommend that they get a loan, which, I mean, obviously a short-term loan.
Exactly.
I also recommend that they get a experienced real estate agent like you, Teresa, to say, do you really need to do this? Or do you really need to do that? Or you really should fix this because it's going to add to value, or you really should do whatever. And, you know, it's just really, really, really good to have a very experienced real estate agent in this area like you, Teresa, because people are grieving. People are emotional. Some people shut down, even if they're the executor. They're like, they miss mom or dad or whoever it is so much that they can't function. It just We all react to death differently.
Exactly. It's really, really hard. I've got a couple of cases right now where the family is doing exactly what you say. When I call to check on them, some days they're good, some days they're not. They're just going through. So I try to make it as easy as possible. I work with the attorneys, just like you and I, we work together, try to get as much done. I remember taking the petition for probate to the different family members' house for them to sign, just making sure that it would be easy for them. Just anything I can do, talking to the attorney, because they're distraught.
Well, one of the things that we try to do that's really easy is, let's say they pick somebody for the executor, like say you, Teresa. Then what we try to do is draft what's called a non-objection. So let's go back to you having the 5 siblings. Then try to get each one to sign a non-objection to that petition. And then the court says, oh, Teresa's going to be appointed because we have 5 of her siblings say they don't have a problem with her being appointed.
Got it. Outstanding. So because the process does take a long time, the families that have done that reverse mortgage, what can they do? Because
when you have a reverse mortgage, it's really no different than a regular mortgage in the sense that if there's equity, there's equity. Mm-hmm. First, the big thing to find out is, did the reverse mortgage take all the equity? And if it didn't, then it's just going to be just the same as a regular mortgage. It was a reverse mortgage. They needed money because maybe they were on a fixed income or maybe they didn't have income or whatever. But as long as there's equity, okay, then it's good to have a trust because you don't want to spend that money on the probate process.
Exactly. And some of the challenges, like what I said at first, sometimes the owner, the parents will take on this reverse mortgage, but they don't tell the children. So then the children come in, they're not on the mortgage account or information, and they cannot get any information because they're not the executor, and they are not the executor because they haven't filed the probate paperwork.
Yeah, but usually at Bailey and Romero, we are very persuasive when we can usually get the information, regardless if they're the executor, not the executor, they're not on the loan. It's fairly, it's not that hard.
That's why I come to you. That's why I come to you. You can handle the business. Oh my God, this is such great information. This is so valuable. So we've talked about probate, we've talked about trust. Now let's talk about bankruptcy. What are some of the things people can file in a bankruptcy and some of the things they can't? I remember back in the day, like 100 years ago, you could file everything, tax liens, student loans, debts, whatever it was. You put it all in the pot and say, here, I'm done. What is it like today?
Well, in 2005, there were a lot of changes to the Bankruptcy Code. And this is because the United States public got fed up of paying higher interest rates and the higher fees because they're paying, but people aren't paying. So in 2005, it took about 15 years to modify the Bankruptcy Code. And so in 2005, we have what's called the Reform Act. Okay. And so what they decided is that nobody can just file a Chapter 7. A Chapter 7 is liquidating everything and have everything discharged. So everybody has to see if they qualify for a Chapter 13. A Chapter 13 will pay off debts over time, okay, either 3 or 5 years. If you show hardship, it'll be 5 years. So they want everyone to pay back something. So if you qualify for a Chapter 13, it doesn't necessarily mean that you're going to pay 100%, although they would love you to pay back 100%. But if your income is such that you can only pay back a percentage of that, whether it be 90%, 80%, 70%, even 20%, they're going to put you in a Chapter 13 because they are tired of people filing Chapter 7, getting everything wiped out, going and maxing up their credit cards again, trying Chapter 7 again, getting everything wiped out, going to do the same thing again and over and over and over. True. So the Reform Act, which is just, we don't call it the Reform Act. I mean, I call it the Reform Act because I'm a bankruptcy attorney, but just the 2005 changes limits now how many times you can file 7, how many times you can file a petition at all. So Chapter 13, Chapter 7. But there are other chapters. that may or may not be applicable. So Chapter 11 is a reorganization of the big major companies. As we know, PG&E, Pacific Gas and Electric, is currently in Chapter 11, second time that they are, and because of all the fires, you know, so they have been found guilty of starting the fires, several fires. And so they are also in criminal court as well. And I don't know if they've been sentenced yet, because I know I read about it, and I don't know if sentencing was last week or this week or next week. I haven't had time to look, but anyway, they just approved the plan of reorganization for Pacific Gas and Electric. So now what they're going to do is start to deal with all the individual claimants and any other claimants that have filed. Could be a vendor, could be, I mean, anyone who has filed a claim, but the ones that are most going to be very sensitive are the 84 people that were burned in Paradise. So that is going to be the most sensitive, because there's going to be a claim for wrongful death, and they've already pled guilty to murdering them. So that's going to be really sensitive. Okay. So there's also a Chapter 11. A Chapter 12 is a family farmer, which is like a Chapter 11. A little bit different. Of course, we look at the Bankruptcy Code, and that's where we see what the eligibility requirements are. And the Bankruptcy Code is really cool, because all of the 7, so it's like starts with, I don't know if it starts with 700, but whatever it starts with, 7, say it starts with 700, that's Chapter 7. Okay, so 13, all the code sections with 13 something, that's Chapter 13. 12, the same thing. 11, the same thing. Then all the 5s are applicable to all of the changes.
Wow.
1 second. You can go out that one. So what was I saying? So so there's a Chapter 11, there's a Chapter 12, and that's mostly like in Fresno or, you know, Central California. They'll have farms, or it doesn't even have to be a farm. It could be an orange grove or just anything agricultural. And then there's a Chapter 9. A Chapter 9 is when a municipality files bankruptcy, like we saw many years ago with Orange County, and then Vallejo filed, Stock filed, you know, in past years. And it also could be a water district, a health district. Many hospitals now are experiencing, you know, a problem with people paying their medical expenses. So it just depends. That's a municipality. It's kind of also like a Chapter 11, but again, there's different, you know, different things that are required for each of the codes.
Wow. Oh my God. I had no idea there were that many bankruptcies.
And then remember, there's 4 districts. There's the Southern District, the Central District, the Eastern District, and the Northern District. And we're Central District, and we have 5 courts within the Central District. And Judge Ty is the presiding judge for the Central District.
Oh my God. Oh man, this is a lot. You're like a walking library, and you just have all this knowledge. You are so amazing. So if a person is considering bankruptcy, mostly the individual, you know, the homeowner or something like that, what type of advice would you give them first? What should they do first?
Well, I have to give a disclaimer, because just because I'm on media does not mean I have an attorney-client privilege with anyone. So this is just a guideline. We like them to have $25,000 worth of debt. I mean, we don't like them to, but in order for a court to have them file, the judge, I mean, if they only have like 5,000 of debt, I mean, they could work that out, okay? Or they only have $10,000 of debt, that kind of sounds like a lot too, but they could work that out with their creditors, especially if they're credit cards. Okay, consolidate them. And so we really like them. I shouldn't use that word like. The threshold should be $25,000, and it can be in unsecured debt. It could be in tax liens. It could be student loans. But again, there's going to be eligibility requirements for of the debt that is owed. So there's going to be certain things about how many years the student loan has to be before you discharge it. And I don't have that right. It always changes. So we just look at the code. I mean, I don't have it memorized right now off the top of my head, but people do have student loans. They do have tax liens. And again, another eligibility. The number one reason why people file bankruptcy is because of medical debt. Because people may have insurance, or they might not, but they might. But then they have some catastrophic illness like cancer, leukemia, or maybe it's a catastrophic accident and the insurance just doesn't cover it. And then they're left with, say 50,000 in medical bills or 20,000 or whatever. The number one reason is medical expenses.
That makes sense. I can see that because you kind of plan for retirement, you kind of plan for savings, or you're going to buy a car or whatever it is, you kind of see those things coming. The large medical, the catastrophic things that happen, it's not planned. So that makes perfectly good sense. Perfectly good sense. So
the next reason that people file bankruptcy is long-term unemployment, because if you can't, especially if it's like a family and their two spouses get unemployed, which we know right now there's millions of Americans unemployed. But we also recommend is prior to filing bankruptcy, of course we look at everything, but we also look at whether they can modify their mortgage. If they have a mortgage, can they modify it? Can they go to the bank? I don't really recommend that they, what's the word? Not pay.
Right.
Because that's just going to get added to the end of the loan, and they're going to have to eventually pay that. Right. And it could be that they extract a higher interest rate or some kind of balloon payment, or I don't know all the terms out there because I don't know what the lenders are doing out there right now. But we don't really recommend that they not pay if they can pay.
Exactly.
I also recommend that if it's really bad unemployment, I mean, like it's a long-term unemployment, whether they can borrow money from family or do they need to sell? I mean, what are they doing about trying to get a job? Or did their unemployment long run out and they didn't have any plans? Do they have savings? What do they have? Do they have to move in with their parents? I mean, what do they need to do? And, a lot of people think that that's horrible. Like these challenges come and they don't know what to do or they shut down. But as any challenge comes into our life, we have to find an effective solution, even if it means we have to sell the family home that maybe that was our dream. But we have to find an effective solution because this is what's going to happen. The bank is eventually going to foreclose on you.
Exactly.
Right now, there's a moratorium on foreclosures, but we won't have a moratorium forever. And then the bank will foreclose, and then you'll be like, what? Now, I have some clients that have really scary, shut down. They never paid their mortgage. They foreclosed. And then one day a knock came out the door and said, your house has been sold from underneath you.
Oh my God. That is very true.
I've had several clients like that, unfortunately. And then, of course, they want them out like yesterday. And so then we have to negotiate.
They show up with the sheriff.
Yeah. Can they have so much time so they can get all their things out? And then, when people aren't really in the know about things like that, then they want to say, oh, well, it could have never been sold out from out of me. I go, well, did you get the notices? So I've had clients that have shoved the notices under their couch, never told their spouse. I've had clients that have, thrown them away. I've had clients that don't know what they say, so they throw them away. I say, no matter how bad it is, take it to somebody that knows something. Don't just shut down.
Exactly. A lot of times when the clients call me, Teresa, I want to sell my house. Okay, great. And so you do the history, the qualifying process. Well, I'm a little behind on my payments and I'm kind of in foreclosure. Okay, no problem, because we know we've got that 90-day window. How far into your 90 days are you? Oh, this is day 80.
Oh,
or this is day 60. I am really great and I know that I can get your house sold, but selling it in 5 days, 10 days from start to finish is a little bit much. Sometimes you can ask the bank for an extension. If you have a solid buyer, if you have a listing agreement, if you have all your ducks in order, I can go and say, please, Bank A, can I please have a extension because we're in escrow. I have a buyer and we're going to close. Here's all of our paperwork, and we have to produce the paperwork. So I know exactly what you're saying.
And we don't like to be in those situations, but people are people.
Yes, and like you said, sometimes they just don't
The
know.
other thing I forgot to say, Teresa, is when you're in probate, you can get an extension from the bank because you're in probate.
Yes. See, I told you that's why you're my girl. That's why I got you. So before we wrap it up, how can people find you? What do they need to do?
We're at Bailey and Romero. We have offices in Northern and Southern California, but I can always be reached at 562-889-0182. We also have a Facebook site, Bailey and Romero, Law and Strategy. And also you could reach me at marthaeromerolaw@gmail.com.
Oh my God, you are just a walking knowledge encyclopedia, dictionary, library. You answered so many questions that I know everybody wants to know. I am so happy that you spent this time with me. Is there any final closing thoughts that you would like to give to your listeners?
Yes, when you're unsure, get help.
Nice. Outstanding. With that being said, I am Teresa Miller with the M&M Team Realty, and you may reach me by calling 310-713-8459. I would love to talk to you. I would love to introduce you to Martha. She's the perfect person to help you with all of your law needs, questions. She has the answers. With that being said, we'll talk to you later.
Thank you, Teresa.
You're welcome.